first offense DUIs in Washington State. If you're interested in this topic, or you've been just arrested or charged with a DUI, this is the video for you. My name is Lance Fryrear, and I'm a defense attorney in Lynnwood, Washington. My law firm has been defending people charged with crimes, including DUIs, for more than 20 years. And let's face it, it's a very scary situation to be arrested for DUI or charged for DUI, and timing is important. So if you're one of the people that have just been charged with a DUI, you're facing one, I'm glad you're watching this video now, because you need to do some things right away. Otherwise, your case can get worse and your results will be worse. So in this video, I'm going to cover three things. Number one, what are some of the penalties for a first offense DUI? That's what everyone worries about. Am I going to go to jail? Am I going to have my license suspended? That type of thing. Number two, what are some things you need to do right away to try to protect your rights and improve your chances in your DUI case? And finally, number three, what are some common outcomes that we can shoot for in DUI cases? What are the magic bullets to make it totally go away? And what are things that we can do, and what type of results can we have that are less than a DUI? So I'm putting out these videos during, post-pandemic time, and I've made a whole lot of videos just to help the public. So if you find this helpful, please like and please subscribe. More people will get the information they need. Now, jumping right in. One, DUI penalties. What are the penalties for a first offense DUI? Well, DUI, of course, is defined as having a breath test within 2 hours of driving of 0.08 or more for alcohol, or having 5 nanograms of marijuana in your blood after a blood draw within 2 hours of driving. And if they don't have breath or blood, then they can also prove you guilty by showing that your ability to drive a motor vehicle was affected in any appreciable degree by drugs or alcohol consumed before or during driving. So that's a mouthful, but that's what they have to prove for DUI. And what are the penalties? Well, this is a first offense DUI video. So assuming it's your first offense, the penalties vary based upon the level of your breath test. There's a certain penalty for under a 0.15, and there's a different penalty for 0.15 or higher. And there's also a different penalty if you have a refusal of a breath or blood test. So if you're convicted of DUI, the standard situation is you have a breath test above a 0.08 but below a 0.15. In that case, there's a mandatory minimum fine with all the costs and stuff. Think around $1,500, but it varies. And a mandatory minimum 1 day in jail if you're convicted. And you can also ask to have that converted to 15 days of home detention, though most people don't want to do that. And a DUI conviction at that level of breath test will carry a 90-day license suspension and a 1-year ignition interlock requirement. If your breath test happens to be 0.15 or above, just up the jail time to 2 days minimum or 30 days home detention, and up the fine by about $500. The suspension will also be longer. Instead of a 90-day suspension, you'll face a 1-year suspension. If you happen to refuse a breath test and you're convicted, or a blood test, and you're convicted of DUI, the penalties are still the 2 days or 30 home detention, still that higher level fine, but instead of a 1-year suspension, it's a 2-year suspension of your driver's license. And for the marijuana type charges, any marijuana conviction will carry the same mandatory minimum penalties as a first offense DUI under a 1.5, so 1 day in jail and a 90 days license suspension. And all these convictions carry a 1-year interlock requirement. So those are the penalties for DUI. Yes, they can be worse than that. Those are the minimums. The maximum is $5,000 and 364 days in jail. Well, what could make it worse than the minimums, Lance? Well, the prosecutor is supposed to take into account, was there an accident? That's supposed to be an aggravating factor. Did you have any passengers in the car? That's an aggravating factor. And also, did you have any passengers under 16 years of age? That's an aggravating factor. And in that case, it will also trigger a longer interlock requirement. So what happens if I get suspended, Lance? Can I still drive? Well, nowadays you can apply for an ignition interlock license, where you have to have an interlock in your vehicle. You have to have what's called SR22 insurance. You need that for 36 months total. And you also need to send in an application with a $100 fee to ask for an interlock license to drive during a period of suspension. So those are the mandatory minimum penalties. Moving on to number 2, what I was going to talk about are, what are the timing things? What do you need to do? Well, the most important thing is the 7-day requirement that if you had a breath test, 0.08 or higher for adults, actually minors are 0.02, so anyone under 21 has a different level. For adults, or if you refused a breath or blood test, you only have 7 days from the date of the arrest to request a licensing hearing. Now, day 1 is the day after the arrest. Okay, so if you get arrested on a Saturday, day 1 is Sunday, but the weekends and the holidays count. And so you need to get right on it to request a licensing hearing. What does that mean, a licensing hearing? It means that when you had that breath test above 0.08 or you refused, the police officer sends in a notice to the Department of Licensing telling them about what happened. And then the Department of Licensing puts your information in the computer, and it's going to trigger a suspension of your license. And that suspension typically starts about 30 days after the arrest. And since your license is a property right, they can't suspend your license without providing you due process, a way to have the officer's actions reviewed and challenged. And what the law now says is you only have 7 days to request that licensing hearing to challenge the police officer. So how do you request a licensing hearing? Well, you can do it through the paperwork that the officer gave you, or you can do it online at www.dol.wa.gov. To request it online, you have to go to your License Express account. And you probably already have one if you've ever renewed a license or renewed a vehicle license. But if you don't, you can establish one. And there's a tip, make sure you establish a personal License Express account, not a business one. And when you get in your License Express account, there'll be a screen that says Requested DUI Hearing. Now, either on paperwork or on the computer, to request that DUI hearing, you're going to need some information. You're going to need to know approximately when you were arrested, the date you were arrested, the agency that arrested you. You're going to need your name, address, phone number. If you have an attorney, you need to put the attorney's information down as well. And you're also going to need to pay to request the hearing. The hearing costs $375 as of August 2021 when I'm filming this. If you don't have the $375, you can request a fee hearing waiver, and there's a form online for that as well. I'm going to link to that in the description. But if you request that hearing fee waiver and it's rejected, you'll have very limited time once you learn of the rejection to pay the $375. So if at all possible, pay the $375. When you request that hearing, and if you do it properly, it's going to put your license suspension on hold. Now, practice pointer, you're still going to get a notice in the mail saying you're suspended on that 31st day, usually for a period of 90 days, could be longer if you refused. But by requesting that licensing hearing, it's going to put that suspension on hold. And the bad news is Department of Licensing is not going to send you anything saying, hey, the suspension's on hold, never mind. So on that 30th and 31st day, you got to be careful. I need you to get online, dol.wa.gov, and you'll be able to find a spot on there to check the status of a driver's license. I need you to check the status of your driver's license to make sure that it's still valid on the 31st day. Check day 30 also, so just be careful. But when you request that hearing, it will put your license suspension on hold if you did it properly. So that was a lot to talk about, that 7 days, but the 7 days is so important because we, as your attorneys, we need that licensing hearing. We need a chance to subpoena the police officer to show up on the telephone as a telephonic hearing, to be able to ask that police officer some questions. Ask them when they're in a relaxed mood. I mean, if they pulled you over at 2 a.m. and your hearing's at noon, they're probably not on duty, right? They might be at home. They might be in their pajamas. They might not be, so totally with it. And so anything a police officer answers during the licensing hearing is under oath, and it's on tape, and they're stuck with that answer. And we can learn things. And that doesn't involve the prosecutor. There is no prosecuting attorney at a civil licensing hearing, which means that there's not a lot of help to rehabilitate any answers that go wrong. And believe me, plenty of DUI cases have turned favorable based upon what happened during a licensing hearing. And the other thing is, if we subpoena an officer to the hearing and the officer fails to appear without excuse, we can get your suspension canceled altogether. Won't make the whole criminal case go away, but let me tell you, not having to deal with a license suspension is a good thing. So what else do you need to worry about? Well, there's some things you can do while your case is pending or even before it's charged to help yourself, right? We're going to likely want you to do an alcohol and drug evaluation, which is calling up a trusted agency that treats people fairly, because there's plenty that do not, and answering questions about your alcohol and drug use history. And that agency is going to make a recommendation for what type of treatment, if anything, they recommend under state guidelines based upon your specific situation. And the minimum they could recommend, and what we hope to see, is an alcohol and drug information school only, and a DUI victims panel after that. If they make a finding, the agency, that there's insufficient evidence you have an alcohol or drug problem, then the state minimum for a DUI says an 8-hour alcohol and drug information school. Plus, you need to do a 2-hour DUI victims panel. But if you do that stuff ahead of time, you look way better for the prosecutor. You're a better risk for them to, take into account your lack of any history and give you a better result. And you're a better risk for the court. You're going to have less probation costs. You're going to feel better taking some action to improve your case. So listen to your attorney, be it us or whoever you're working with. But that's what we would typically have a client do unless there's an exceptional reason not to. So those are some things you need to do right away. Get that licensing hearing requested. That's the most important. Get the alcohol drug evaluation if your attorney wants you to. It's a really good idea. And get a hold of an attorney, because the other thing that many firms do, not all of them, but we have quite a few attorneys, so we really, really try to protect our clients. We're going to want to request to preserve any video that's in the breath test room if you had a breath test. There's typically video there, and oftentimes it gets recycled because it's a hard drive. There's not a bunch of discs that are burning or old time VHS tapes, and we need to preserve that because it will not be preserved otherwise. And if the officer did some things wrong, we're going to see it on the tape. And we've actually had cases that have totally had a different outcome because we got a hold of that BAC, that breath test room video tape. And that's going to get recycled typically in a week or two in many jurisdictions. So move quickly, because moving quickly will help you have a better chance at a better outcome. So thanks for staying to the end. Number 3, what are some possible outcomes of your DUI case? Well, there's the worst case scenario. You're found guilty of DUI, and we already talked about what the penalties are. But there are other situations too. Your charge could get reduced to a lesser charge, to reckless driving with no mandatory jail time, no mandatory interlock, and only a 30-day license suspension. And if you already suffered a 90-day suspension on the civil or administrative side, that 30 days gets absorbed into the 90, so it really is no suspension. You could also get it reduced to negligent driving in the first degree. There's also no mandatory jail on that, and no suspension on that, and no mandatory interlock in most cases. That's a really good thing. Let's say your case is terrible, and you ran into another car and you had 3 passengers and you blew a .30 and you're afraid you're going to go to jail, you're going to lose your job because you need to drive for your work. Well, you could also do deferred prosecution. It's not typically recommended for a first offense, but deferred prosecution is where you do a 2-year treatment program and have no crimes for 5 years, and you can end up getting your whole case dismissed. And if you didn't refuse, you could avoid suspension altogether. Why don't people just do that on a first offense? Well, because you can only ever do it once, and usually the penalties aren't so terrible on a first offense that you'd want to sort of burn your one, the magic bullet where you can really work hard to earn a dismissal of the case by changing your behaviors and getting the treatment you might need if that's the situation that you're in. Could a DUI case get dismissed? Yes, DUI cases do get dismissed, but usually only for a legal reason. A bad stop by the police officer, a bad informant tip, a breath test that is so low it's ridiculous, or let's say it's a prescription drug, DUI, and it's therapeutic levels of your medication, and there's reasons why you displayed things that the officer thought you were affected and you weren't. So it's complicated, but DUIs can get dismissed, but it's usually due to legal reasons that we don't always know about until we get police reports to try to help. So I hope you found this video helpful. It is not a hopeless situation. A first offense DUI is inconvenient. It feels like the end of the world, I know, but typically it is not. And if this is the situation you're in and you want some help, feel free to give my office a call. Again, my name's Lance Fryrear. My firm has been defending people charged with DUIs for more than 20 years. We have multiple of our attorneys have actually been through the field sobriety test trainings, the same ones that the officers take. We handle DUIs every day. We know what it's like, but give us a call. We'll see if we can help, and we'll be there for you. Thank you.